Contracts 1 in English language. Most important questions and tips to face the exam successfully. Dear student friends, I wish to take up this lecture in English medium from the subject Contracts 1 General Principles. Most important questions or topics from examination point of view, and also I wish to give you some tips as to how to face the examination successfully. I made a beginning of these lectures with a strong and deep inclination to cover 30 subjects, but I would able to upload lectures on 18 subjects. Meanwhile, at the request of my student friends, I started delivering in Telugu language also. When once I started repeating in Telugu language with good improvements and with good improvement and latest development, I also started uploading in English. So my students who wish languages, who wish my videos exclusively in English media, need not worry. Most of the lectures are uploaded in English language only. The title means itself in English media only. Telugu media are few. When a video is uploaded in Telugu, in the very beginning at the caption, you can find in Telugu or in Telugu language. All the videos are in English only. So far I uploaded 228 lectures. This is 229 lectures, 29th lecture. More than 150 lectures are in English media out of 18 subjects, which are the main subjects not only for LLB examination but also for judicial officers exam and competitive examinations. That is why I am giving more information on these subjects. Anyway, some students are requesting me to upload other subjects also. It is not possible to upload all the subjects at a time because you know the volume of law subjects. So for the convenience of students of all classes, first year to final year, I have decided to give in the first instance a summary of the subject and most important topics from examination point of view. Now I wish to complete the first semester remaining 2 or 3 subjects and then proceed to second semester, and then finally I will proceed to most important subjects CPC, CRPC, evidence, and some other important subjects from competitive exam, constitutional law, administrative law, family law and others, taking into consideration the syllabi prescribed for competitive exams, judicial officers exams. I will cover all one by one. In this lecture, I will take up most important topics from examination point of view. This is Contracts 1. In Contracts 1, the subject is a small subject when compared to TOTS and IPC. Students need not worry. However, Contracts 1 will be the first subject while entering into legal education, because this subject become students must have studied under the head mercantile law. In 5-year course, students in some universities, first year or second year pre-law, law subjects also have been introduced. But technically speaking, 5 years course pre-law, first 2 years English and social sciences are prescribed in most of the universities. And law subjects start from third year of 5 year integrated course. 3 year LLB course, all law subjects will be there. I told you earlier, first year, earlier 18 subjects were prescribed for 3 year LLB. Subsequently, in 2000 academic year 99-2000, subjects increased it to 18 to 28, and from 2008 academic year, the number of subjects increased it to 30 subjects. Now all the students, so for a 3 year LLB and 5 year law subjects are concerned, there are 30 law subjects. Others are for pre-law students, other subjects. In addition to that, there will be some elective subjects depending upon the university's concern. Now, I suggest you, dear student friends, when you want to prepare for any examination, you select the best book of your choice. Don't rely absolutely on the suggestions of teachers or syllabus book, the books prescribed. When you want to choose a particular book, you go there, go to bookshop, read out the contents of a particular book as per your capacity. If the contents of the book are suitable to your knowledge, you choose that book. It may be a small book or containing 100 pages, or it may be a big book containing 1000 pages, depending upon your capacity and your ability to prepare for the examination. You choose it. Then whatever book you take, if you want to maintain latest developments, it is absolutely necessary to go through internet and see the articles. Whatever subject you want to prepare, you call that particular subject PDF. You will get number of PDFs. You take into account the latest date of PDF, so that you will be able to get latest information. So even if latest book is there in market, just released in a few months, but from the time the book is completed, during the process and the time it came out, it may take some 3 to 6 months or even a few months. During that period also, new developments may take place. That is why you have to refer internet for latest developments. And in latest interview articles also, you have to take into account the latest date. Latest date is important. Sometimes in internet, this latest information is not uploaded. You will have to find out the same from concerned law professors or judges or distinguished members from legal profession for that. So this is what I had to do while teaching consumer protection subject long back. Now coming to the when once you choose a book, you have to give novel reading of that book. That is first page to last page, or first chapter to last chapter. That is summary of the subject. You have to give some novel reading. So when you give novel reading, you will have some idea about the whole subject. You will have the idea about whole subjects, that is from first chapter to last chapter. To complete the book, whether how hours you require, how many days you are required, how many weeks you require, it depends upon your capacity to read the book quickly, and your capacity to digest the book contents quickly depends upon your capability and memory power. So when once you give a novel reading from first chapter to last chapter, you will have an idea, overall idea about that subject. What is this subject? What are the contents therein? Each subject, each chapter speaks about what, you will be able to understand. Then you will have to choose the best topics from examination point of view. You have to take into consideration volume of the chapter, importance of the chapter, interest you can have while reading that particular chapter, how best you will be able to remember. You have to select. Suppose the first 2 3 chapters may be voluminous chapters, but if you spend most of your time for that, when once you go for later chapters which are more important from examination point of view, the problem will take place. So as students, as beginners, you find it difficult to know which is the best chapter, which is the easy and interesting, which chapter questions are there are face chances in question, which chapters which questions are likely to appear in exam. You don't have any experience, and that is why I wish to tell you, I wish to enlighten you on these issues. So when you find it difficult to, if you go to college regularly and attend classes regularly from first day to last day, subject to few absence, you can have overall idea about the subject. You need not go for this thing, reading the book completely. Suppose anyway, when once you start the preparation, it is necessary that you should know overall, you should have overall idea about first chapter to last chapter, and then you can pick out the most important topics from examination point of view. For this purpose, I suggest you, dear friends, in case you could not go to college regularly, in case you cannot find it possible to give novel reading to all the chapters, first chapter to last chapter, I suggest you to watch the summary which I gave just in 2 classes, that is 2 hours. In the beginning, I gave summary of contracts 1, and for a revision also I gave summary of contracts 1 and 2. I covered almost all chapters in English long back. Now again I repeated contracts 1 for the purpose of Telugu students also second time. That is why I thoroughly explained contracts 1 in detail. In earlier I covered all the chapters. Subsequently I have covered all the topics, both English and Telugu language. So you have enough literature for preparation. Now what I want to tell you is, when you write the exam, the first 2 3 questions must be presented very effectively, so that the examiner will have impression. First impression will be the best impression. I don't mean that you should not write all the questions excellently, but when once you will be able to write 2 or 3 questions, first 3 questions very excellently, the examiner will form some opinion about your candidature, and he will be able to award you very good marks. So for this purpose, from any subject you choose 5 questions or 5 topics which are very important, most important from examination point of view. For contracts, I am giving you, there are totally 11 chapters are there. 11 in a contract act also 11 chapter 1 to 5 75 sections deal with principles. Remaining chapter 6 to 11th chapter covering 260 up to 266 deal with specific contracts. These things I told you long back. You take 5 questions and prepare synopsis or short small notes in a notebook for your convenience. First you take 5 questions. After completing the 5 questions, irrespective of serial order in a syllabus, and the best topics from examination point of view, after completing 5 questions, you proceed for 3 more questions, and then in third phase you proceed for the remaining topics. what are the topics that are to be selected in the first instance, I will read out, and the second instance, second phase, three topics, and remaining in the third phase, I read out first and will explain you how to answer those particular questions. I will which topics are very important, how the questions may be asked, if the questions are asked in different styles, how you will have to face the examination, I will enlighten you. So for contracts 1, in first phase you are selecting 5 questions. What are the 5 questions? First, you have to take contract, meaning, definition, elements and kinds. Details of this I will explain in detail. First, I read out all the 11 topics in order of priority. Then, first topic wise, I will explain you how questions may appear on this particular chapter, how to answer this chapter, and I will tell you. First one is contracts. First chapter, contract, meaning, definition, elements and kinds. In kinds, void contract or voidable contract may be asked as short notes. The contract, meaning, definition and elements may be rarely asked as directly, most of the times indirectly. How it will be asked we will discuss later. Though the first question is contract, meaning, definition and element. After completing the first chapter, preparing the first chapter, you have to invariably by heart some sections, 2 or 3 sections, I will let you know. And after completing contract, meaning, definition, elements and kind, the second topic you proceed to is quasi contracts, that is last chapter of the subject. Quasi contracts, section 68 to 72, 5 kinds of quasi contracts. So question, essay question may be asked, one of the quasi contracts may be asked as short notes, and tips I will explain in detail. First topic you have to prepare is contract, meaning, definition, elements and kinds. Second topics you have to prepare is quasi contract. Directly you go to quasi contract. After completing quasi contract as the second topic, now you proceed to third question or third topic, capacity or competency of parties. Capacity of parties or competence of parties, section 11 and 12. Section 11 minor contract is most important. In section 12 lunacy or unsoundness may be asked as short notes. How the question may be asked, how the question is to be answered, I will let you know later. First question contract, meaning, definition, elements. Second question quasi contracts. Third topic is capacity or competence of parties. Particular reference to the minor contract or rule in Mughri Bibi versus Dharmdas Ghosh. We have to third 3 topics are over. Then fourth one is remedies. In remedies chapter, this is not only important for this, but it is a general topic. As a law student, you are expected to know various remedies available. The remedies, the headings in the remedies you come across throughout your legal studies. There are various kinds of remedies. What are restitution of property, specific performance, damages, injunction, like that. Different kinds of remedies will be there. These remedies not only important for the question generally may be asked, what are the various remedies available in contract? You have to write all the remedies. When once one of the remedy may be asked at short notes. At least if asked 1 or 2 remedies may be asked at a short note. How the question may be asked, I will take up later. Fifth topic is consideration. In consideration, there are 2 big questions. One is a contract, meaning, definition and elements of contract, elements of consideration, or a contract without consideration is void with exception, section 25 clause 1, 2 and 3. That is first topic. So the second topic is a stranger to contract cannot sue, but a stranger to consideration can sue. So in this chapter, consideration is comparatively more voluminous. So it is the volume of this chapter is more when compared to these preceding chapters, quasi contracts or contract. So in consideration, the question ex nudo pacto non oritur actio like this. So here in first phase, I suggest you concentrate first on 5 chapters and prepare a working notes on that. Put with a good number of side heading sections, cases. You have to go underlining sections. You have to underline the cases and all. These questions, first phase, 5 topics are refined one serial order. Contract meaning, definition, elements, etc. Elements in kind. Second question, quasi contract. Third question, capacity of parties, minor contract. Fourth question is remedies. Fifth question is fifth in remedies. There is the most important topic in remedies is how assessment of damages or calculation or computation of damages. The leading case is Hadley versus Baxendale. In tips, I will explain in detail. So, contract meaning, definition, element. Second, quasi contract. Third one is capacity or competence, minor contract. Fourth one is remedies, Hadley versus Baxendale. Fifth topic is consideration. Consideration without contract without consideration is void. Exceptions is one question. Second question, a privity of contract or a contract without a stranger to contract cannot sue, but a stranger to consideration can sue. Is next. So these topics you prepare thoroughly. Not less than 2 questions will appear. 2 or 3 questions will appear in the examination. Then when you, after successful completion of these 5 topics and preparing a working note, then you proceed to phase 2, 3 questions. Now here you go to first question, that is the 6th question, is communication of offer and acceptance. Communication of offer in after chapter you take the pick out the communication offer. In acceptance chapter, you pick out the communication of acceptance in this. So the question may be asked, communication of offer question may be asked, communication of acceptance may be asked, or communication of offer and acceptance, both may be asked collectively. Sometimes communication of offer may be asked as a short question, or communication of acceptance may be asked as a short question. When once this or the communication short notes may simply asked as Lalman versus Gauri Dutt, the case may be asked. Then this case refers to communication offer, and then you have to write about communication of offer. So the second, after completing 5 questions under first phase, the second phase, the first question is communication of offers and acceptance. From offer and acceptance chapters, offer to A, acceptance to B, you should concentrate on some short notes. So these short notes are nothing but elements of, they are from elements of offer or elements of acceptance only. They are not separate. But these topic, invitation to offer is very important from short notes. Invitation to offer is very important. Some general offer, short note. Invitation to offer may be asked as short notes. General offer or Carlyle versus Carbolic Smoke Ball Company Limited. The case may be given. If case is given Carlyle versus Carbolic Company, this case Carlyle versus Carbolic Company, company refers to general offer. Then you write about general offer meaning, and then you give the write about Carlyle versus Carbolic Smoke Ball Company, the facts of the case and everything as short notes. So cross offer or revocation offer may be asked as a short note. Similarly, standing offer or open offer or open offer or continuing offer may be asked as short notes. Then in second phase, first question is about offer and acceptance with particular reference to communication of offer and acceptance and a short note. Sometimes the question may be asked, what is offer, what is acceptance, that is the gunpowder matchstick quotation also may be asked about this acceptance. So that is also Janssen's quotation may be given sometimes to answer this. So that is offer and accepted. Second question is legality of object or lawful object. In second phase, first question is offer and acceptance. Second question is legality of object or lawful object. So contracts opposed to public policy are void. So here 26, 27, 28, 29, 30. 30 wagering contingent contract, it will be studied as separate chapter. But out of 26, 27, 28, 29, 27, a contract in restraint of trade is void is most important. A contract in restraint of trade is asked 90% important. Some others may be so in agreement restraint of law may be asked as short note. In agreement in restraint of marriage may be asked as short note. But in agreement in restraint of trade may be asked sometimes as full question, essay question, and sometimes asked as a short question. So the second one is legality of object topic. In agreement in restraint of trade is most important. Next, third question is wagering contract. Wagering contract. Now, in second phase, three topics you have to prepare, and you prepare a work knowing notes also. Number one, offer and acceptance. Second one is legality of object or lawful object with particular reference to agreement in restraint of trade you have to concentrate. And third question is wagering contract and contingent contract. It is a very small chapter. If there is a likely essay question, I suggest you to follow this wagering contract and contingent contract, and these two contract, either wagering contract or contract contingent contract, short note may be asked, essay question may be asked, and the question may be asked on the difference between wagering contract and contingent contract. So that is why in second phase you have to concentrate three topics. First one is offer and acceptance, that is communication of offer and acceptance, and a short notes, invitation to offer, standing offer, open offer, general offer, cross offer, etc. Next, second question, legality object, section 27, agreement in restraint of trade. Third one, wagering and contingent contract. This is full chapter you have to read. So the second phase, the three topics you have to complete. Next, you go to third phase. Discharge of contract is very big chapter. So many topics are there. That is why I asked you to keep it last. In discharge of contract is very big chapter. In performance and discharge, I explained in detail in the respective lectures, both English and Telugu. In any way, in discharge of contract, you concentrate two topics. One is the doctrine of frustration. The doctrine of frustration, section 56. Second one is the doctrine of novation, 62. The frustration may be asked as essay question. Novation may be asked as a short question. These two. And the rule in Clayton case also you may prepare. And rule in Clayton's case. And apportionment of debt. Apportionment of liability. Debtor's liability against creditor is the topic, that is the evaluation of liability you have to concentrate also. But from discharge of contract, frustration of object and novation are important from examination point of view. So in third phase, discharge of contract, two topics I said, and then you proceed to free consent. So free consent, the concept of consent you come across throughout your studies. This consent you come across in law of torts, criminal law, and so many areas, marriage, law of marriages, that is Hindu law, Muslim law, everywhere the consent plays an important role. Without consent there is no contract. So how the contract is the consent has influence in various concepts you have to discuss. But in consent, section 13, 14 is there. Section 13 is consent, 14 is free consent, and if the free consent should not subject to coercion, undue influence, fraud, misrepresentation, that is misrepresentation, mistake. So these topics, consent section 13, free consent section 14, coercion 15, undue influence 16, fraud, misrepresentation, knowingly misrepresentation is fraud, 7, unknowingly misrepresentation is misrepresentation, and lastly mistake 20 and 22. These topics you have to prepare. So dear friends, so you have to, you may think that our Rao sir is telling all the topics, there are only 12 chapter 11 chapters, but I have eliminated so many things. I have asked you to read these topics in the first instance. So I want to tell you some more tips. So I told you, read 5 questions or 5 topics in the first instance, first phase. That is, number 1, contract. Because as a student of contracts, you have to know the subject. You should make a beginning with first chapter only. Normally, every question paper contains first question from introduction chapter only. That is why I suggested you, there is no hard and fast rule that the first question is to be answered first. You may answer last question first, middle question and second question. Which question you will be able to answer well, you pick out that question. It may be short notes or essay question, whatever it may be. When once you make a beginning, you complete the complete question. Suppose a question contains 3, 4, 2 or 3, one question may contain 2 or two short notes or 2 quotations like this. But whatever it may be, you have to finish the particular question and then proceed to best question. Like that, you read, suppose the contract meaning, definition and element. You have to write the contract meaning, you have to write the definition, section 2H definition and section 10. These 2 definitions you have to write. You have to write meet in 4 lines, 2H just 2 lines only. Section 10 definition is some 4 or 5 lines you have to write. Then elements, you have to write offer and acceptance 2A, 2B. You have to give side heading, consideration 2D, consent section 14, free consent section 14, plus 15 to 22, like that. And side heading, if you know the sections, you have to know. And capacity 11 and 12, legality of object section 23, subject to 26 and 13. And like that, you have to write the elements of legal consequences, performance of contract, section 36 is attracted. All these things, elements you have to write if the question is asked directly. But sometimes, normally, the question is asked in agreement by enforceable law is contract discuss. That is the question. So, an agreement enforceable by law is contract is asked. This quotation or phrase refers to section 2H of the Indian Contract Act, which defines a contract. To justify this question, we have to write the meaning, definition, elements. Elements, meaning, definition, elements you have to write. Kinds of contract you need not write. Sometimes this question is asked in another way. All contracts are agreement, but all agreements are not contract. Then you have to write. The given phrase or instant phrase, all contracts are agreement, but all agreements are not contract, is correct. Because agreement is an improvement. Correct contract is an improvement over agreement. In agreement, is contract is made out of agreement, provided the contract is valid. Only valid agreement which can be challenged or enforceable before court of law only become contracts. Otherwise, they remain as agreement. An agreement may be valid or invalid, but contract may be valid only. Contract is all times valid, but agreement is not valid all times. Just like a mother maybe a married woman may not be a mother. Some mothers, some married women do not have issues. They are simply married women. They cannot. But of course, there are some exceptions in illegitimate child birth cases. But we should not take into consideration that. So, but every MA is BA, but every BA cannot be BA. We should not. We have to ignore direct MA without basic qualification. So, BMA means after BA, MA. MCOM means after BCom, MCOM. So, this is what you have to keep in mind. The first question, meaning, definition, and elements, so direct question may be asked. Otherwise, an agreement enforceable by law is contract may be asked. A contract, all contracts are agreement, but all agreements are not contracts may be asked. If you asked, you can write that. Now you have to prepare an essay on this because it will be easy for you to prepare before the examination with side headings, sections, cases, etc. Then after contract is over, in a kinds of contract are there. Valid contract already here. Void contract you have to write the you have to by heart. You have to the void contract may be asked as short notes. Voidable contract may be asked as short notes. These aspects illegal contract also may be asked as short note, but illegal contract refers to section 120A, 120B Indian Penal Code. So this is now second one is quasi contract question. Sometimes you define quasi contract and what are the various kinds of quasi contract. Question is asked. Section 68 to 72 of Indian Contract Act lay down various provisions relating to 5 quasi contracts. Like that may be asked. Some quotation may be given. So there are not contract, but there the contract those resemble contracts. That the word, when you find the word resemble, then you can identify that it is a quasi contract. And or there may become quotation, no one shall enrich any benefit at the expense of other. And one should not get any benefit from another unjustly without any justification. Enrich benefit, if you find the word enrich benefit and resemble you find, then you assume that it is quasi contract. This statement, this quotation refers to quasi contracts. So, section 68 to 72 of Indian Contract Act deal with 5 kinds of quasi contracts. You have to write the 5 questions quasi contracts. That question meaning definition. Sometimes only short notes may be asked in contract. So minors quasi contractual obligations for payment of necessities. Necessities paid to necessities provided to minor. Minor is liable. That is section 78. Like that non-gratuitous act or payment made by mistake or finder of lost goods. So necessities paid, necessities given to, necessities provided to minor 68 or this what is called finder of lost goods. These two may be asked as short note. But the question is asked on essay question, you have to write all the 5 questions, 5 topics. Quasi contract, second question is over. Third one is capacity of parties. Capacity of parties, this topic minor, this capacity or competence of parties you find in so many subjects. Company law you find it, Transfer of Property Act you find it, and many other subjects you will have to face this concept of some special kinds of person. These capacity you find in law of contracts, you find it in criminal law, you find it in Transfer of Property Act, and various other subjects also. These minor and other disqualified people you will find, and when they are made qualified, you have to know. That is why I suggest you to concentrate on this capacity of parties or competence of parties. Mean who are the persons competent or qualified to enter into contract. That is general rule. But this chapter deals with some legally disqualified persons to enter into contract. So what are these legally disqualified persons? Minors, unsound, lunatics and others. So in this, among these, the minor contract, what is contract entered into with minor is void, discuss. The question may be asked. Or what is the rule laid down by Muri BBS Dharmdas Ghosh? Question may be asked. If the question is asked, the rule laid down in Mohri BBS Dharmdas Ghosh, you have to write that it relates to contract entered into with minor. PV Council said that contract entered into with minor is void, and then you will have to write. And loan unsound mind short notes may be given, and some other topics are there. Convict, insolvent, they are negligible. If the full essay question is asked, you have to cover all the things. Next, third question is capacity is over. Now fourth question is remedies. There are different kinds of remedies. There are different kinds of specific performance is there. Payment of damages is there. Restitution of property is there. Injunction or different remedies are there. If question is asked, what are the various remedies, you will have to write all the remedies. Suppose one or two remedies may be asked as short note, you have to write. So the quantum of damages may be, what is the rule laid down in Hadley versus Baxendale? The rule laid down in Hadley versus Baxendale refers to assessment of damages. Assessment of damages, quantum of damages, or calculation of damages payable in a contract. That is what you have to write, and that is the topic. Sometimes only Hadley versus Baxendale case is given, then you will have be required to give write short notes. And if it is that question is given, Hadley versus Baxendale, this case refers to assessment of damages. It is one of the payment of damages is one of the remedies available to the plaintiff who bring an action against the defendant. Like that you will have to write. So fourth question, remedies, is over. Next question, fifth question is consideration. Next to offer and acceptance, consideration is most important element. Consideration means something in return or price of the contract. In this, the question may be asked, what is defined consideration, what are the elements of consideration. Consideration meaning, definition and elements you have to write. Otherwise, a contract entered into a contract without consideration is void. Discuss what are the exceptions. So, if contract consideration is not there, the contract is not valid, it is invalid, that is void. But however, there are three exceptions. Section 25, clause 1, clause 2, 3. Love and affection, payment, payment for past services rendered. Third one is time bound debt. You have to write this. So another question is privity of contract or stranger to contract. A contract entered into stranger is void, or what are the exceptions? A contract entered into stranger is void, but a contract entered into a stranger to contract cannot sue, but a stranger to consideration can sue. This is the question. In consideration, there are two topics. First question is what is consideration? Define consideration. What are the elements of consideration? That is direct question. Indirect question is why contract entered into consideration. A contract without consideration is void. Discuss what are the exceptions. Or a contract without consideration void. What are the exceptions? Question may be asked like this. So the second that is elements of consideration, or a contract entered into consideration is void. That is first question. Second question is a stranger to contract cannot sue, but a stranger to consideration can sue. This also will have exception. These two questions you have to ask. If question is asked, either that question or this question may be given in consideration. In first phase, 5 questions are completed, 5 topics. In second phase, questions are asked communication of offer. So offer is one chapter, acceptance is third chapter. First chapter is contract meaning, definition, elements as per syllabus. Second chapter in the chapter is offer. Third chapter is acceptance. but the offer meaning definition elements of offer, elements of acceptance are almost identical. But the thing is, offer is more important than acceptance. But acceptance, one question is there, answers quotation is there. When once acceptance is made, it cannot be revoked, it cannot be withdrawn. How? A mastic is mastic, lightning mastic touches gunpowder, a blast will come, it explodes. Like that, when once you put a fire to petrol or some explosive, you cannot prevent it, it explodes automatically. Like that, when once an acceptance is made, it cannot be revoked. That is why that question is there. So the offer and the communication of acceptance, when once acceptance is completed, it cannot be revoked. That is the topic. That area you have to concentrate. In offer and acceptance, there are short notes in there. Elements of question may be asked, define offer, what are the elements? Question may be asked, define acceptance, what are the elements? Or what is communication of offer and acceptance may be asked. Only communication of offer may be asked. Communication of acceptance may be asked. From this short notes topic, invitation to offer, it is one of the elements of offer. Standing offer, a general offer, specific offer also, short note, it is one of the elements under offer. So invitation to offer, standing offer or open offer or continuing offer, all are same. These are the topics. Sixth question. Next, in second phase, I told you second question is lawful object or legality of object, section 23. So when a parties enter into contract, the object of the contract, purpose of the contract must be good and lawful. It must not be unlawful or illegal. It must not be opposed to public policy. It must not be opposed to public policy. Prostitution business is opposed to public policy. If consumption of alcoholic drinks is prohibited by the government, it is maintaining bars and maintaining wine shops is opposed to public policy. If ban is there, like that, opposite to public policy are there. An agreement in restraint of marriage, void. You should not enter into contract. An agreement in restraint of law is void. An agreement in restraint of trade is void. An agreement containing uncertainty of contents is uncertain contents, it is void. Wage agreement, wagering and contingent agreements are void. Like that, legality of object or lawful object, for you have to concentrate. So many opposite to public policies are there, but you concentrate section 27. In agreement in restraint of trade is void. Also article 19(1)(f). Also this topic is studied with reference to article 19(1)(f) of Indian Constitution. So these are the 8 things. So in second phase, you have to read offer acceptance. Secondly, legality object, section 27. Third topic, wagering and contingent contract. Wagering contract may be asked as short note. Contingent contract may be asked as short note. The difference between wagering and contingent may be asked as short note. Or some essay question may be asked on wagering and contract contingent acts. So these 3 topics are to be prepared in second phase. You have to prepare working notes on these 3 topics. So the third phase or last phase is chapter 1, discharge of contract. Discharge of contract is a big chapter. So many topics are there. I suggest you to pick out first section 56, frustration, doctrine of frustration or frustration of object or impossibility of performance. And the second one is section 62, novation. Section 62, novation. Thereafter, devaluation of property and rule in Clayton's rule in Clayton's case also you can read. So with this, the syllabus will be over. So finally, I tell you, you give summary reading of the subject or watch my summary lectures too. As all I have on the almost all 18 subjects, I have given summary lectures just in 2 classes, and that is 2 hours. But the difficulty is my lectures are 1 hour and above 1 hour. Students find it difficult to have patience to patient hearing. But what can I do? I have I have undertaken to upload number of subjects, almost all subjects. The all the subject 30 subjects must have been uploaded by this time, but because the response of student is very slow, so I did not like to give boring to my student friends. I have now and then I am getting throat trouble, throat infection. Recently I was out of station for Andhra Pradesh, Hyderabad and other places, and I got throat trouble again. That is why I have this gap. But there are thousands of subscribers, but all of them are not utilizing. But final year students and second year students are making use of the lectures effectively. But I made a beginning to cover first year students. So first year students comparatively do not know the importance of my lectures. 5 years final year students for the second year student, they have good experience with my lectures and classes, so they are making more use. First year students do not have that. Anyway, they will be able to come to they will be able to know shortly. um, Only due to throat trouble now and then I am unable to give, but still I am ready. My student friends are asking succession second semester, so I better give important questions and summary, both in English medium and Telugu medium, so that they will follow. Please follow my lectures, dear friends, because it is very, you don't find uh, all the subjects I am placing before you in 1 hour. More volume, whole chapter I am placing before you. At the same time, I am giving you latest developments which we don't find in textbooks. I am reading the articles designed for civil services and other top authorities, articles of students and teachers from reputed institutions. If you make use of my lectures, you can enrich wonderful knowledge. After this, in a day or two, I will give most important questions and tips from law of torts. Next subject, next constitutional law one, and first semester I will complete it. Thereafter, first of all, let me complete. Students are asking, we want environmental law. Some asking, we want succession. Some asking, let us give at least summary in the first place, and labor law also is there. 29 legislations are consolidated into 4 codes 4 years back, presented in Lok Sabha, but these labor codes have not yet been passed into law. But I am in due to dilemma when I stopped revising labor law textbook also because of this. I stopped it in the middle, but then waiting for that. So I would have uploaded lectures on labor law long back, succession Muslim law long back, but so many students are asking me to upload Muslim law. In fact, I am very eager, very anxious to upload all the subjects, but unfortunately, incidentally, I had to go to some places, tours. My throat is giving trouble. This is one reason, but students are not responding that much. Due to, if you respond to my lectures very quickly, I can have more inspiration. Anyway, I will do my best during my lifetime, because in next generation what my lectures I may not be available. It is for you to make use of my lectures. So I want to do something in my life, I am doing. Thank you very much.